Good afternoon. I'm Howard Nations, and I'm your attorney in the AFFF MDL litigation, which is on file in the Federal District Court in South Carolina. So let me just explain that to you right off the bat. This is an MDL, which is multi-district litigation, and that's where you have lawsuits filed all over the country, but they all have the same basic issue and the same roots and the same legal issues. So they put them all together into one lawsuit to try to get them resolved in one lawsuit. And in this case, it's in the Federal District Court in South Carolina. Now, in this one, it's really a big, complicated MDL because there are 4 different types of plaintiffs in this case. We have manufacturers who are suing the 34 defendants in this case. We have municipalities who are suing the defendants in this case. And we have plaintiffs who had exposure to toxic water who are suing. And then we have this group, our group, which is the AFFF group, who are also suing as part of the personal injury recovery in this lawsuit. So the judge decided right off the bat that he wanted to handle this as a global settlement. And so that means that he appointed one global mediator to try to get the whole case resolved. And by the whole case, I mean all the cases, all the suits by manufacturers, all the suits by municipalities, all the suits of personal injury for either toxic water or for the AFFF. And that is a highly complicated matter. So that's one of the reasons this has been going on for years. And during those years, this would keep growing. We'd think we had it under control and we would be ready to start trying to settle it. But then the cases kept growing and we kept getting more and more cases. And so the mediation that was taking place, where the global mediator kept trying to pull together money out of the 34 defendants, and we're talking about billions of dollars here. And then we'd find out that there were a lot more plaintiffs than we thought because people had not filed suit. There were so many people who hadn't filed suit. So the judge finally entered the order that we're dealing with today, and why we're making this call with you, because he's put a deadline, a very strict deadline, on getting control of how many cases there are, how many are legitimate, how many are going to be part of the settlement, and how many are going to be dismissed. And so where we are right now, there are 125,000 claims now, where we started with 15,000 a few years ago. Now there are 125. The problem with that is there are, as the leadership has advised the court, a lot of those are duplicate claims. And I mean, a substantial number are duplicate claims. A lot of them, at the end of this litigation, when they were gathering cases, there was a lot of fraud showed up in these cases. There were a lot of fraudulent claims being prosecuted. So the judge said, okay, here's what I'm going to do. In order to settle this case, the first thing we have to figure out is how many legitimate cases do we have. So he set up this system to identify the legitimate cases, which will then move forward into the settlement negotiations, or to eliminate the fraudulent claims and to eliminate the duplicate claims. So we can get down to a group. You can't try to figure out a settlement until you know how many legitimate claims you have. So he set up this format, and it's really been difficult for us to comply with this, and because it requires so much cooperation from the plaintiffs, and it requires a lot of new signatures, a lot of new documents to be filed. Now, I have sent out to each of you a USPS 2-day envelope. You should have received it Monday. And in that envelope, we have set out all of the documents that need to be signed. And I'm going to go over those with you today and tell you, you can figure out whether they apply to you or whether you don't need to sign a particular document. So in that 2-day USPS envelope is a return envelope, and it is prepaid. So all you have to do is take the documents that you need to execute, you need to sign, and sign them and put them back into that prepaid envelope, put them in the Postal Service, and it's $12 for the each direction, but we've already paid it, so you don't have to worry about that. Just put the paperwork back in there and give it to your postman. Now, the problem in this, and the big distinction in this, and the reason I need to go over all of this with you, is the wet signatures that are required. If we could just do this by DocuSign, where we send you documents and you click on it and sign it, it wouldn't be a problem at all. The fact that 3 of the documents require wet signatures is a huge problem, because we don't have the wet signatures. For example, on the HIPAA forms, we have to have the proof of your injury. And so the proof of your injury will be found in your medical records. And we've been negotiating for a long time as to whether or not we should have to produce all their medical records, or whether we could just simply have a diagnostic code, maybe 3 or 4 pages of medical records. But so what we're having to do is, on each of your cases, we have to file all this matters that the judge has set out in this order he set, and we have to establish now and upload evidence. We have to upload medical records and all types of evidence to prove that you had exposure, to prove what your loss was, to prove what your injury is, and to make an argument as to what your damages should be. And without those documents on file, we won't be able to participate in the settlement. So the big thing right now is, we'll talk about it as we go through the documents, but the big issue and the main reason you have those envelopes is the wet signature, which means that you can't stamp it, you can't type it in, you can't DocuSign it. It requires a wet signature, and I'll show you on the documents as we go through which ones require the wet signature, which is why I sent you the USPS return envelope, prepaid envelope. So all you have to do is make the wet signature and then sign the other documents, put them back in the envelope, and they'll come back to me in a 2-day turnaround. The judge's purpose is to identify legitimate claims, eliminate fraudulent claims, eliminate duplicate claims, and eliminate claims of people who are just not going to participate in the settlement, who don't want to participate in the settlement, so we can get that number of 125,000 down to a manageable number. Once we get past that manageable number, then we'll be able to talk settlement in terms of literally how many billions of dollars it would take for us to move forward at this time with settlement. And it is billions of dollars. And when the first case came to trial, it was a manufacturing case. And on the eve of trial, they paid $12 billion. They made a settlement of $12 billion with the manufacturers that were the ones that had the trial setting. They made it on the weekend before they picked a jury on Monday. Well, we're not doing that. We're going straight to, we're not going to have to wait for a trial setting, because what we're going to do is we will take this information, we will upload it into the portal, and it'll go to the defendant, and it'll be filed with the court. And then the defendant can then review what we file, the evidence that we file, and then we can eliminate all the cases that are not going to move forward. Then we move forward into settlement negotiations, but we'll be in settlement negotiations only in those cases where we've been able to produce evidence, which includes mainly medical records, the nature of your injury, nature and extent of your injury, and then some other records that you have on the PFS, which I'll talk to you about in just a moment. So what started as a pretty simple single lawsuit is now highly complex, and the court is determined to get these, to eliminate all the cases where there's no interest on the part of the plaintiff in moving forward towards settlement. There will be substantial funds paid out. There will be billions of dollars paid out in these cases. So the question is, do you want to participate? Do you want to move forward and be one of those people, one of the people that have a legitimate claim that's going to be paid? So let's start through the process. I'm going to go through the documents with you, and these are the documents that you have in the USPS envelope that you received. And so I'll go through these one at a time and tell you what they are and what you need to do with it. The biggest deal is the PFS, now the plaintiff fact sheet. So the plaintiff fact sheet is where you did not give a deposition in the case, you didn't have to file interrogatories, answers, you didn't have to do all that. What you're doing instead of that is you have to fill out your plaintiff fact sheet. Now, each one of you has a lawyer and a case manager in my office assigned directly to your case, and you can work with your case manager to answer any questions if you just want to go through it with question by question. Just call our office and ask for your case manager, and they'll go through the filling out of the whole PFS for, I think it's 14 pages. And they'll go through all that information. We've already pulled all the information that we have and put it into the fact sheets, but there's additional information that we have to have. So we'll need you to fill out the fact sheet yourself, and then if you run into a stumbling block on something that you don't feel you can move forward with, then we'll do it with you. Now, if you'll zoom in on that for a second, I'll show you. The plaintiff fact sheet, what you're signing here is a verification. This is just a verification page. Now go down to where right there. Okay, so this one, it just needs a signature of the plaintiff and print your name. And this page, this one page, we'll put that on the end of your fact sheet, because on the end of the PFS, when you fill it out and we get it all done, then when we file it, this has to go on the end of it. Without this verification, it won't be accepted. And without this verification, this is your evidence of the case that we're uploading. So you absolutely have to sign this fact sheet and print your name and date it, put it in the envelope and send it back to me. Now, let's go to the next one, which is, there are two different types of fact sheets, and those of you to whom this applies will know what we're talking about here. You also have turnout gear. Turnout gear is where it was finally figured out that the actual gear that the firefighters were using actually had the toxins within the gear itself. And so that's a separate claim because it's a different manufacturer. So you have the turnout gear plaintiff fact sheet. It's a TOG PFS So this is the same thing. All you're signing here is one page, and you can see the signature line. Just zoom on that. You can see this one's simple. It's just got a simple, you just answer here, and then you go down to the verification, signature of the plaintiff, print your name, and that's it. And this is just a normal signature. This does not have to have a wet signature, so but while you're doing it, just go ahead and sign it, and with a wet signature, but it's not required. You can type it in, you can write your name in, whatever. So that's the other plaintiff fact sheet that we need, because it's a different manufacturer. Okay, now this is really crucial to what we're doing here. This is a HIPAA form, and on this HIPAA form, this is what allows us to get your medical records. And then we get the medical records, and we screen the medical records. We go through them, and we pull out all the information in there that gives us argument as to the nature of your injury, the extent of your injury, and all your prognosis, your surgeries, your pharmaceuticals, what kind of drug regimen you're on, all that sort of thing we can get. Because zero in at the top there, and we'll pull that up and see, we designate what we want from them, from the medical provider. And you see what we put. We want any part of medical records or the entire medical records. So we're getting the entire medical records because this is evidence that we have to prove your injury. Now, if you'll scroll down, you see that there are two additional, in addition to the, and this is wet signature now. So in addition to your name at the bottom, where you have to sign your name with a pen, then you have to put your initials here on the release of significant information. And then the other is potential information related to reproductive health care. So those two, you just have to put your initials on that, then go to the bottom and do a wet signature, and that'll get that done for us. And then that way we'll have that. We can't prove your damages. These are your damages. Your damages come out of your medical records. If we can't get your medical records to file, we can't prove your damages. All right. Now this is a HIPAA operation authorization. This is a special one for the VA. This will apply only to those of you who have VA records who were in the military. So on this one, it's the same thing. It's the VA HIPAA, and if you were in the military, then you need to sign both of those. You sign the regular ones that we can use for your doctors and hospital. Then we sign this one, which we would use to get your military, your VA records. So this, again, wet signature required. This is the SF 180, and this is a form that has to be filled out. And you fill out the form, it's not that difficult. But the hard part of it is, once again, this requires a wet signature. You have to use a pen. You can't type your name in. You can't use a DocuSign. You have to write your name with a pen. So the wet signature is required on this. And then, now this, you'd wonder what this is. Why do I have to send in a mental health form? Okay, the judge has ordered, and you'll see this one's simple because at the bottom you simply need to sign it. This does not require a wet signature, but you can sign it. This is only a signature. But this, we have to sign this and send it to the defense. You're authorizing the defense to get these records. And the court has ordered this to be produced because they're entitled to have it. So if we don't produce it, then there's not going to be, we won't be able to get this, and then they will object to it, and they'll call it a deficiency and see if they can get the court to agree to dismiss your claim for failure to produce this. The other one is the defense non-mental health authorization. It's the same, it's just that it covers both of them. Same thing, just one signature does not have to be a wet signature. So on this is something that the court has ordered that we produce to the defendant, and it's the water exposure authorization. All you have to do is sign at the bottom where it says customer. This won't apply to a lot of you, but go ahead and sign it. We have to send it to them. We have to give it to the defense. So go ahead and sign that, and we'll send it on to the defense. Now, those are the documents that you need to sign, and put back in that envelope and get them back to us. Because if you do that, then we can get your medical records in a short period of time, and we can get them in time to comply with this timeline. This is the very strict timeline that we're on. That started in April 24, and we're coming up on the 98 days now. So phase one, which is that we have to pull together all of these documents and all these papers that have to be signed and file them. And we have to file evidence of your injury, upload it to the portal. So we must substantially complete the PFS within 90 days of filing your lawsuit. So that's why we need you to file for this. We can't file that PFS without you signing the PFS authorization. The first group that comes up on 90 days will be like November 28th. So we're just a couple of weeks away from that, and then after that, they're day by day. And we have between now and December 16th for the last group. So we have to file these with the court. And if we don't file this, what happens to this once they're filed is the defendant will notify the court that there's a deficiency if we don't file it. If we didn't have the PFS authorization, for example, or if we didn't have any medical records, then the defendant will notify us that there's a deficiency. Your application is deficient because it does not include medical records, or it does not include medical authorization, the mental health authorization. And then they will give us 28 days to cure that. So we'll have 28 days to come back and say, okay, we are ready now. We're getting one more chance, but we have to have this PFS authorization signed. We have to have the HIPAA form signed to get your medical records, and then we'll be moving at a very fast rate, because within 14 days, we have to meet and confer with the other side regarding any disputes we have over what's been provided and what's not. And after that, the defense can file a motion to compel compelling us to answer, to produce these documents. We have 14 days to respond after they file a motion to compel. We have 7 days. They have to file it within 14 days. We have 7 days to respond. And then and then this will just be ruled on by the court. There's not going to be an oral argument. And then each plaintiff may request one extension of 21 days to serve a PFS, but we have to have it first. If no PFS is served, defendant shall send notice of noncompliance letter to us, allowing us 14 days to comply or to respond with a compliance date, and to meet and confer with them on why we haven't provided them with medical records. After that, response to the motion to dismiss needs to be filed within 14 days. If there's no compliance, and this is the part you need to read carefully, if there's no compliance, the court will dismiss your case. So if we don't have these things that we're supposed to have, the court will, if we don't produce these things when they're supposed to be produced, and you can see we get 2 or 3 opportunities to produce them, but that first one starts in 2 weeks. So we have to have all these things done, and we're going to have a very intense period in here. And in order to get those done, we have to have the documents signed by you and returned to us in those return envelopes, so that we can provide those with to the defendant and file them in the portal and get answers from the defendants on what they claim is deficient. So the other things that are happening is we're going to have to provide this information. So, but we have to do a lot of things with this information after we get it. For example, just getting the medical records from the hospital is not enough. We have to go through your entire medical record and look for proof of your injury. We have to look for we'll make a list of the pharmaceuticals that you're taking. What is your drug regimen? What surgeries did you have? And what future surgeries are you scheduled to have? What type of therapy were you on? What type of therapy are you on now? These are all these things all make up the damages that you have in the case. But we have to do all that after we secure medical records, and so we need them as soon as possible. And so if there's any question about that, you have a case manager and a lawyer assigned to your case. In addition to me, I'm assigned to all the cases, but you have a case manager and a lawyer assigned to your case to help you in all of this, to answer any questions you have about what to sign, what not to sign, or what else you need, or how to get it to us, or what is this for. I hope I've answered your question about what this is for. I will this is serious, because we got billions of dollars on the line, and this is what you have to do in order to get your share of it. And the people that we already have all these things on, we've already got ready to upload when their day comes. But so when your day comes, we need to have yours ready to upload. But especially the PFS is important, because that's all the information that goes into your into the deliberation about what your case is worth. You can fill out as much as you can of the PFS, both of them. You can fill out as much information as you can and put it back in that envelope and send it in. And if you don't know the answer, leave blanks. And then when the case manager gets it, they'll look at it and they'll see the blanks, and then they can call you to fill in the blanks. The case manager will fill in the blanks. But you fill in as much as you can, and then we've already filled in quite a bit, but you fill in as much as you can, and then send it back to us, and then we'll help you fill in the rest of it. But then you absolutely have to sign that one-page PFS verification and send that back in. So there's plenty of help available to you to fill out these forms, to do whatever you have to do to comply. Now, this is very important. You can see all the things we have to do with your file in the next 2 or 3 months before we get down to the actual negotiation. So we have to be in touch with you. Be sure that you keep us up to date on if you change your phone number, if you change your mailing address, But we have to be able to talk to you, because we can't talk to you. We can't reach you to tell you this is due. You've got this due. I can fax it to you right now, or email it to you right now, or text it to you right now, and have you sign it, send it back, that kind of thing. But we're going to need you to help fill out these things and make sure everything is signed, to be sure that your case is on file. So I said I was going to do 30 minutes of explanation, and then I'll open it up now. Anyone who has a question, if you want to go into the chat room, you see chat at the bottom of your screen, and you can write out your questions with the chat. And then let's bring Sadler Bailey in. Sadler Bailey is reviewing. He's an attorney who works with me on these cases, and he's reviewing the chat questions. So let's, Brittany, if you want to add Sadler in, we'll start with the questions.
Howard, the primary question is from people who say they have not received a package, and they just want to know what should they do if they have not received the package that you're talking about.
Okay. If we didn't send you a packet, if you have previously filled out, it may be because you've previously filled out all these things, and we didn't need anything else from you. But if you haven't previously filled out all these things, call the office and ask to speak to your case manager. And then your case manager will go over with you over the phone exactly what you have to do. But we sent out the people on this call are people that we're in touch with, and we have a lot of information on you already, but we have something was missing. So we sent things out so our case managers can call you. You can call the case managers and find out what your status is, and what you need to be filing, and what you don't, what you've already filed. So check in with your case manager. And Brittany, we have a couple of 800 numbers. What's the best number for them to call on this?
They can just call our main office, which is 713-807-8400.
Okay. All right.
A client wants to know, how do I know if I've done everything correctly, or if there's something else that you need from me?
If we still need things from you, we're still going to be reaching out to you. We'll be taking your phone calls. We'll be trying to call you. We'll be texting you. We use text, emails. I'm sending out soon. I'm going to send out an email with a video link in the email telling you what specific thing we need from you. But the thing to do is, if you don't know, just call the office. Call the office number she just gave you. And how about the 800 number? Is it going to be effective to, which of the 800 numbers should they call, Brittany?
Let me grab that for you, just one moment.
We have a couple of them. Now we have a total of about 70 people working on this. We have 70 employees who've been working on this for years, and they make calls to clients. The big problem we have is the clients don't answer the call. That's the biggest problem. If you answer the call, then whoever's calling you from will tell you exactly what we need from you, or you can call in to.
The other number is 855 888-0806.
Okay. And that gets to the main office?
That one goes to our 24-hour line.
Okay. Okay. All right. Next
You've got an
question.
inquiry. Yeah, here's one that says, "Can I just get my lawyer's direct line for simplicity's sake?"
Um, no, because it's the case manager that is doing all the initial stuff. And then your case manager, you can call and ask to talk to your case manager, and your case manager can put you, it depends on, the lawyers change around on these cases sometimes, but the case managers are always there. So you can call the case manager and tell the case manager that you want to talk to the lawyer that's working directly on this case, and they'll get you on the line with him.
There's a little concern about the form about mental health records, and we've got people saying, "What's that got to do with anything on my
That
cancer?"
is something that the court has ordered to produce. The court ordered us to produce that. It's nothing unusual. That's just a form that the DOJ uses for the health or non-mental health records, and that's just their form. And the court has ordered that it be signed, that it be produced to them, authorizing them to get whatever records they want to get. And again, if you don't sign it, it's a deficiency, and I don't know if the court would regard that as a sufficient deficiency to dismiss the case, but because we don't know what that's going to happen to it does. Next question.
Okay. Yes, I saw one about, are we handling PFAS cases? I think that's what it was. It's
PFAS. Yeah,
not-
this is all part of that same. Everything is about PFAS, and there's so many different areas of litigation on that now. But yes, this is the eternal toxin, the one that doesn't get out of your system. So
we're handling the AFFF as well as the PFAS claims.
yeah, well, yes.
All right. Someone inquired as to whether it matters. Do we need to sign these documents in blue ink?
No, just wet signatures. Oh, it's better if you have a pen with blue ink. It's better because it doesn't show up like a black ink. Too often looks like it's a stamp or something, or that it's not a wet signature. But it doesn't have to be in blue. Don't run out and buy a blue pen just for that.
Do we have any idea of a possible settlement timeline?
Yes, well, I can give you the timeline. It will take, from the last thing you've seen on the board, it'll take, we have to have these in by December 16th is the last date for doing the first part, which is filing. That's the end of phase one, which is the December 16th. That's when we have to have everything in for the last group that filed their lawsuits. And then after that, we have to wait. We'll wait for a while because it takes the defendant a while to review what we file and to mark deficiencies. So whatever time, let's say it takes them 30 days to mark deficiencies because they have 125,000 of these. And so if they take 30 days to mark deficiencies, and then they send them back to us, and we have 28 days to respond. So that's January and that's February to respond. And then if there's anything more needed, we'd have to have a meet and greet within 14 days. If we have they can file a motion to compel, add another 14 days. We have 7 days, that's 21 days. That puts us into March. And then absent order, and then we have at that point, we have to be in non-compliance. It puts us into, if we follow this thing will take through April, and I think that's as fast as it'll go. Now, it could go a lot slower because our 28 days doesn't begin to run on curing deficiencies until the defendant notifies us of the deficiencies. So if they get caught up in trying to handle 125,000 of these and mark all the deficiencies, whatever time that takes before they get it back to us, our 28 days doesn't start to run until then. But if everything moves swiftly, it'll be this process could be over by, say, May 1st. Then they have to take the time to, at that point, they'll have all of the fraudulent cases. We assume people won't prosecute their fraud any further, since they can't do this because they can't submit their medical records. They can't submit any evidence. That's why he's requiring evidence. They can't submit any evidence, so those will fall by the wayside. And those who just don't want to prosecute their case anymore, that'll fall by the wayside. And then duplicate cases will also fall by the wayside. So then we'll get down to about, hopefully in May, we would be down to be able to say, okay, we have 98,212 cases that are legitimate, or 55, whatever it is. We'll have a body of legitimate cases that are going to participate in the settlement identified by, say, May 1st. And I think that's optimistic, but that's the best it could be. All right, at that point, since we know what they're dealing with is they're saying, okay, we're only going to put up $10 billion. We're only going to put up $10 billion to cover these personal injury cases. And I'm going to say, well, and I'll say, well, if you're only going to put up $10 billion, you should only do $10 billion worth of damage. In this case, you've done about $15 billion worth of damage when you take all this personal injury cases together. So then we'll go back and forth on figuring out what those are, and what the final numbers are, and see where we get to on the final numbers. Now, another question?
How do I find out who my case manager is?
You can just call the office, and the receptionist will, call the office, and the case manager will do it. Is there any shortcut on that, Brittany?
No, it'll be best to call the front desk, and then they'll be transferred over to their case manager.
Yeah, the front desk will. If you call during off hours and you get our answering service, then you can tell them that you're trying to contact your case manager, and please have your case manager contact you. And then we'll give that call to the case manager and leave your phone number where you want to be contacted. And then we'll have the case manager contact you. Next question.
I think that's it, Howard.
Okay, well, let me tell you a couple more things you need to know. It's been back and forth from the beginning. I mean, we've been working on these things for years. And it's been there's been all kinds of experts. And in order to prevail on this case, you have to have expert witnesses who say that your exposure to the firefighter foam was a cause of your injuries. And so we started out with a whole bunch of injuries that were potential. But the expert has to testify from a body of science, and the expert has to cite medical studies that show that the client had testicular cancer, and that the medical studies show that testicular cancer is caused by exposure to the AFFF, and without that testimony, the expert's testimony has to be approved by the judge, and the judge has to have hearings where they'll hear the testimony of the expert, and then they'll decide, and then they'll look at the science, and then they'll rule yes, the science supports causation. So then the judge will say, okay, the science clearly supports causation. This expert is clearly qualified. So testicular cancer is a compensable injury, and it is. Okay, that's been established. So we've gone through that. Well, in doing that, we've lost some because the judge says no, there's not enough science backing that up. And so it's gone back and forth and back and forth. And lots and lots and lots of science presented to the judge. And at this point, this is what the judge put in his order. And you'll know exactly what I know when I give you this. The judge said this order that we're doing all these things on, it should apply to testicular cancer, kidney cancer, liver cancer, thyroid cancer, ulcerative colitis, and thyroid disease. Those are the 6 that the judge said that we should submit proof on if we have them. If we have these injuries, we should submit proof on these. Now, these injuries do not have the same value. So a testicular cancer is worth considerably more than thyroid disease, for example. Thyroid cancer is worth more than thyroid disease. So what we have to work out once we get the number honed down to the number of legitimate, when we know the number of legitimate cases we have, then we'll go back through and say, okay, of those, let's say there's 100,000 legitimate cases. Okay, then we'd have to go back through and say, okay, of those, 10,000 are testicular cancer, 20,000 are kidney cancer, 15,000 are liver cancer, and so forth. We'll have to see how many we have in each category. And then we'll find, for example, that thyroid disease far and away has the most cases. So then we have to go through each one of those, considering the number that we have. Then we have to go back through, and when I say we, I'm talking about the mediator, the Department of Justice, the defendants, I'm sorry, not DOJ, the defendants, and us, and we have to figure out, okay, here's how many testicular cancers there are. Now, let's put a value on testicular cancer. And so then usually they'll put a range on testicular cancer, but it won't be it'll be a narrow range. And then, okay, this is how many kidney cancer we have. Let's put a range on that. This is how many thyroid cancers we have. And then they do that, put a number on each of the diseases, then they multiply it times the number of diseases, and then they see how close they come. the defense was seriously, I mean, you can't put any final numbers on anything, but earlier they were on $5 billion, and now it's more like $10 billion for our portion of it. But that will change drastically. That could change drastically when they wipe out all the fraudulent claims, and when they do away with the duplicate claims, and then they take out the number of claims of people that are just not that didn't get their paperwork in on time or that sort of thing. So right now, those are the 6 injuries that we're dealing with. That does not obligate the judge to say, okay, I'm going to allow recoveries on all 6 of those injuries. But this was the judge's list, not mine. This is what the judge said we should apply this formula to that he talked about. All these things that we have to submit evidence on. This is what he wants us. These are the 6 diseases he wants us to submit evidence and proof on. So, all right. Any other questions?
Is there any way for you to approximate how much is going to be paid for any of the particular types of cancer of our clients?
No, there's not, because the numbers. It's all about the 2 numbers. It's the number that they say the defendants, that the mediator can get the number up to. If say they get him up to 10 billion, there are 34 of them, so it's there's a lot of negotiating to do. Let's say they get up to 10 billion, and then say, well, we get the number down from 125,000 down to 100,000. Okay, then we'd look at, but all these 6 are not going to be worth the same thing. Then we'd have to figure out, okay, what can we do with $10 billion to cover 100 of these? But then suppose the number comes down to 50,000 legitimate cases. And then the defense might say, well, we're not going to pay $10 billion if you've only got 50,000. So the 2 things that we've got to come down to is how many compensable injuries do we have, and how many billions of dollars do we have? Those 2 things. And we have to make those 2 match up for each individual type of disease. So that's quite a lot of math. After that, what happens is everybody has to sign a release, and the releases have to be signed and returned to the defendant before they get paid. Now, what's happened on this in the past, and we don't know how it's going to happen yet because we're not at that point. Sometimes they will put up the money, and then they'll say, okay, they'll take an individual lawyer and say, okay, you have 2,000 cases. When you get to 90% of your releases turned in, okay, that's 1,800 of them. When you get 1,800 come in, we'll pay everybody. That's when we'll issue checks. We'll issue checks to those 1,900. Or usually we argue it down to 80%. When you get 1,600 out of 2,000 releases returned to us, that's when we'll pay. So it depends on that's going to depend on how long it takes. Now, they could say, and this does happen occasionally, okay, as you turn in releases, the master of the guy who's the settlement master, who's the best that there is in the global settlement business, they may set up a pot. He may say, okay, you give me control of your $10 billion. And then you over here on your side, once a month, you send me all of your releases for each plaintiff lawyer. You send me all the releases that you have for each month. And then we will distribute funds to that month, to everybody in that month. And then the next month, all the releases that come in, we'll pay all those in that month. So it all depends at the end on what the defendants and the settlement master decide to do. The advantage of this being an MDL is it's not a class action where you have to have everything done. Everybody has to be paid at one time. These are individual cases. They're filed as individual cases in an MDL. So it's possible, for example, it's possible that they could set up a way, because they want these things, at that point they want these things disposed of too. So it's possible it'll be set up on some reasonable period after you send in your release, your individual release, you'll get a check. But so all that puts it into the fall. Now, the best news is you don't. Let's say you end up with 100,000 claims, legitimate claims. The best news is on a lot of settlements, you wouldn't get anything until you got 80% of all 100,000 of the cases signed up. You'd have to have 80,000 releases in before they'd pay anything. So that's the worst case scenario. So it's going to be, we don't know the answer to this question until the settlement master and the defendants tell us what the answer to the question is. But of course, we're trying to get money as soon as humanly possible, and we make it very easy for them. And by the way, that's another reason you absolutely want to stay in touch with us. You would not believe how many people we're in touch with, and then we finally we get the releases in, and we finally get the money, and we got the money in the hands of a third party who handles it, and we can't send it out because we don't have the correct address. The defendant has moved, and the plaintiff has moved, and we don't have the address where to send the money. Or we don't have bank wire. It might be a bank wire. We don't have bank wire information. So it's absolutely critical that you stay in touch with us at all times. Keep us up to date every time you change a phone number, anytime you change an address, and you might even send in a second phone number besides yours that we could reach you in the event that you can't be reached. So, well, that's about it. Are there any other questions?
Just a few more questions. What happens if someone were to pass away either before the settlement or before the disbursement of the money?
We would open. It wouldn't influence anything. We simply file a declaration of death with the court. You got a suit on file, so we'd have to file a declaration of death with the court. We'd have to open an estate for the decedent, and then we'd substitute the administrator of the estate for the plaintiff.
What happens if someone develops an injury after these deadlines that you've been talking to us today?
The statute of limitations. Statute of limitations is already run. If it's a new injury, statute of limitations is already run. It might be, I'll tell you something. Right now we got a lot of people that are not going to get paid on this. So we're working on another piece of legislation right now in the United States Congress for firefighter foam. And it will mandate that people be paid. It doesn't leave it to the court as to who gets paid. It'll mandate who gets paid. And we're working on that. So anybody we get that doesn't get paid, for example, prostate cancer is not going to get paid on this round, but we've got prostate cancer in that new bill that we have in Congress, and we're working hard on getting that passed. If that bill's is passed and signed, then you just have to prove that you have a prostate cancer as a result, this, and you just have to qualify for a statutory recovery for prostate cancer. And we're working hard on that. We're spending a lot of money on that, and we're doing a lot of lobbying on that. So,
you mentioned earlier the 6 types of cancer that the judge had identified, and so what advice do you have for those who don't have one of those 6, but they have something else, such as prostate cancer? What shall they do?
Well, they're not going to be in this settlement.
Okay. Do you want them to still?
No, we're holding on to prostate cancer cases, and we'll advise the clients on prostate cancer that we're holding their cases because we're trying to get this, and in case something comes up in the future. But right now, this is all this judge is going to do on this case. Now, there could be additional science come up in the future, and somebody may be able to come back, and these issues are not closed out. If somebody comes in with a new cancer, and the science supports it. For example, there's a lot of scientific study being done right now on prostate cancer. And we talked to the judge about it. And they said, no, he said, I can't wait. He said, I'm not going to wait for prostate cancer. I'm not going to hold everybody up on a settlement, wait until they finish science on prostate cancer. So, but there might be some other new cancers that new science comes up. Then we'll have to look and see what the situation is at that time. So, but right now we're dealing with these 6, and they're actually 4 cancers, and then ulcerative colitis and thyroid disease. All right, any other questions?
Would you tell us those 4 again that are going to be compensated?
The best cases, clearly supported by science, absolutely supported by science, are testicular cancer and kidney cancer. The weaker cases in terms of the support by science, but there's still enough support, and this is what we've been trying. There's been so much work done on trying to convince the court on these, that there is sufficient science on liver cancer and thyroid cancer. And that's been a close call. And he just put those back in. He did a bunch of Daubert hearings on those to see if they're qualified. And then the other 2 are ulcerative colitis and thyroid disease. So those are the 6.
Okay. Now, a lot of people send in questions that are really particular to their injury, and so I'm not really going to burden you with those. I'm just going to say to those people to contact their case manager.
Exactly.
Is that what they...
Exactly. Contact your case manager who has a lawyer working right there with them. And if they don't know the answer, the lawyer will.
And then others have apparently in their possession medical records that maybe you don't have.
Oh, yeah, God, thanks for mentioning that. If you have medical records, go send them in. Send them directly in to my office. And whatever you have in terms of medical records. Also, you have the right to your medical records. Go to your hospital and tell them you want your medical records. Those medical records belong to you. They don't belong to the hospital. And tell the hospital you want you could speed this whole process up and you want to make sure you get in, go to your own hospital and get your medical records. They should produce them for you very quickly, and you're certainly entitled to have them. And if any hospital gives you a hard time about giving you your medical records, call us. Call our receptionist and tell her you need to talk to one of the AFFF lawyers, and we'll see to it that we take care of that. And then, so get your own records. You can get your own pharmaceutical records by simply asking for them. But it would help greatly if you do go get your own records and send them in as soon as possible. The other thing you can do is, if you're in the military and if you're looking for military records, you can go to your own military portal and look at your own military records. And the same thing in the VA. You can go to your own portal in a VA and get your military records and send them to us. That's the medical records out of the military.
Lastly, Howard, a client writes, "Thank you. This has been very informative, and I think that speaks for all of us. So, very much appreciated. Thank you."
Okay, well, we appreciate it. We're looking forward to getting all your medical records and everything in as soon as possible. Like I say, we got 70 people in the firm working on this, so we're ready when you are. So, okay, well, thank you. Thank you for the honor of representing you, too. Appreciate it.